Last case in Right to Counsel, Chapter 5, is called Ross v. Moffitt, 1974. Like many other states, the North Carolina appellate system is multi-tiered, providing for both an intermediate court of appeals and a Supreme Court. North Carolina authorizes appointment of counsel for a convicted defendant, appealing to the intermediate court of appeals, but not for a defendant who seeks either discretionary review in the state Supreme Court or a writ of certiorari in the U.S. Supreme Court. In one case, the Mecklenburg County forgery conviction respondent sought appointed counsel for a discretionary review in the state Supreme Court. In another case, the Guilford County forgery conviction respondent was represented by a public defender in the state Supreme Court, but sought court-appointed counsel to prepare a writ of cert to the U.S. Supreme Court on federal habeas corpus. An unanimous panel on the U.S. Court of Appeals for the Fourth Circuit, per Hainsworth C.T., held that Douglas' rationale required appointment of counsel in both instances. Justice Rehnquist delivered the opinion of the court. In Griffin, the court struck down an Illinois rule allowing a convicted criminal defendant to present claims of trial error to the state Supreme Court only if he procured a transcript of the testimony adduced at his trial. No exception was made for an indigent defendant, and thus one who was unable to pay the cost of obtaining such a transcript was precluded from obtaining appellate review of asserted trial error. Next page. Griffin and succeeding cases stand for the proposition that a state cannot arbitrarily cut off appeal rights for indigents while leaving open avenues of appeal for more affluent persons. In Douglas, however, the court departed somewhat from the limited doctrine of these cases and undertook an examination of whether an indigent's access to the appellate system was adequate. The Douglas court concluded that a state does not fulfill its responsibility toward indigent defendants merely by waiving its own requirements that a convicted defendant procure a transcript or pay a fee in order to appeal, and held that the state must go further to provide counsel for any indigent on his first appeal as a right. It is this decision we are asked to extend today. The precise rationale for the Griffin and Douglas lines of cases has never been explicitly stated. Some support being derived from the Equal Protection Clause of the 14th Amendment and some from the Due Process Clause of that amendment. Neither clause by itself provides an entirely satisfactory basis for the result reached, each depending on a different inquiry. We emphasize different factors. Due process emphasizes fairness between the state and the individual dealing with the state, regardless of how other individuals in the same situation may be treated. Equal protection, on the other hand, emphasizes disparity in the treatment by the state between classes of individuals whose situations are distinguishable. We will address these issues separately in the succeeding sections. Recognition of the due process rationale in Douglas is found both in the court's opinion and in the dissenting opinion of Justice Harlan. The court in Douglas stated that when an individual is forced to run this gauntlet of a preliminary showing of merit, the right does not comport with fair procedure. Mr. Justice Harlan thought that due diligence issue in Douglas was the only one worth extended consideration. We do not believe that the Fourth Amendment clause requires North Carolina to provide respondent with counsel on his discretionary appeal to the state Supreme Court. At the trial stage of the criminal proceeding, the right of an indigent defendant to counsel is fundamentally and binding upon the state by virtue of the 6th and 14th Amendment, but there are significant differences between the trial and appellate stages of a criminal proceeding. The purpose of the trial stage from the state's point of view is to convert a criminal defendant from a person presumed innocent to one found guilty beyond a reasonable doubt. To accomplish this purpose, the state employs a prosecuting attorney who presents evidence to the court, makes any witnesses offered by the defendant or challenges any, argues rulings of the court, and makes direct arguments to the court or jury seeking to persuade them of the defendant's guilt. Under these circumstances, reason and reflection require us to recognize that in our adversary system of criminal justice, any person hailed into court who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for him. Gideon is the citation for that. So, by contrast, it is ordinarily the defendant rather than the state who initiates the appellate process, seeking not to fend off the efforts of the state's prosecutor, but rather to overturn a finding of guilt made by a judge or jury below. The defendant needs an attorney on appeal, not as a shield to protect him against being hailed into court by the state and stripped of his presumption of innocence, but rather as a sword to upset the prior determination of guilt. This difference is significant for while no one would agree that the state may simply dispense with the trial stage of proceedings without a criminal defendant's consent, it is clear that the defendant need not provide any appeal at all. Kane versus Durston, the fact that an appeal has been provided does not automatically mean that the state then acts unfairly by refusing to provide counsel to indigent defendants at every stage of the way. Unfairness results in only if indigents are singled out by the state and denied meaningful access to that system because of their poverty. That question is more profitably considered under the equal protection analysis. So, language evoking equal protection rights is prominent both in Douglas and in other cases. To declare themselves absolute is their logical extreme. There are obviously limits beyond which the equal protection analysis may be pressed without doing violence to principles recognized in other decisions of this court. The 14th Amendment does not require absolute equality and precisely equal 14th Amendment does not require absolute equality or precisely equality advantages, nor does it require the state to equalize economic conditions. Griffin, Frankfurter, J. concurring. So Griffin was the citation for that quoted text. Does not require absolute equality or precisely equal advantages, nor does it require the state to equalize economic conditions. Nor does it, Griffin, look at Griffin for more on that. Frankfurter concurring. Does not require that indigents have an adequate opportunity to present their claims fairly within the adversarial system. The state cannot adopt procedures which leave an indigent defendant entirely cut off from any appeal at all by virtue of his indigency, lien, or extend to such indigent defendants merely a meaningless ritual, while others in better economic circumstances have a meaningful appeal. Douglas, quoting Douglas, the question is not one of absolutes, but it is one of degrees. If this was, in the case that we do not believe that the Equal Protection Clause, when interpreted in this context of these cases, requires North Carolina to provide free counsel for indigent defendants seeking to take discovery appeals to the North Carolina Supreme Court or to file petitions for certiorari in this court. Facts show that respondent, in connection with his Mecklenburg County conviction, received the benefit of counsel in examining the the record of his trial, and in preparing an appellate brief on his behalf of the state for the Court of Appeals. Thus, in preparing an amicus brief, he told his behalf for the state Court of Appeals. Thus, prior to his seeking discretionary review in the state Supreme Court, his claims had once been presented by a lawyer and passed upon an appellate court, Douglas. We do not believe that it can be said, however, therefore, that a defendant in Douglas's circumstances is denied meaningful access to the North Carolina Supreme Court, simply suggesting the state that does not appoint counsel to him in any review in that court, and that stage will have to be, at the very best, a transcript or other trial record made of trial proceedings, In many cases, an opinion by the Court of Appeals imposing of this case, period. These materials supplemented by whatever submission Carolina can make pro se would appear to provide the Supreme Court of North Carolina with an adequate basis on which to base its decision to grant or deny review. We are fortified in this conclusion by our understanding of the function served by discretionary review in the North Carolina Supreme Court. The critical issue in that court, as we perceive it, is not whether there has been a corrected adjustment of guilt in every individual case, but rather whether the subject matter of the appeal has significant public interest, whether the clause provides legal principles of the principles of major significance to the jurisprudence of the state, or whether the decision below is in probable conflict with the decision of the Supreme Court. The Supreme Court may deny certiorari, even though it believes that the decision of the court is was incorrect, since a decision which appears incorrectly may nevertheless fail to satisfy any of the criteria discussed above. Once a defendant's claim of error are organized and presented in a lawyer-like fashion to the Court of Appeals, the justices of the Supreme Court of North Carolina who make the decision to grant or deny discretionary review should be available for ascertain whether his case identifies the standards established by the legislature for knock-in. This is not to say, of course, that the sale, that a skilled lawyer, particularly one with some experience and not what arcane art of preparing filings for discretionary review would like to review in the comparison with the wealthy defendant who has counsel assisting him in every conceivable matter at every stage in the proceeding, but both the opportunity to have counsel prepare an initial brief of the Court of Appeals and the nature of the discretionary review in the Supreme Court of North Carolina make this relative handicap far less. The handicap borne by an indigent defendant denied counsel on his initial appeal as of right in Douglas, and the fact that a particular service might be a benefit to an indigent eventually defendant does not mean that the service is constitutionally required. The duty of the state under our cases is not to duplicate the legal arsenal that may be privately retained by a criminal defendant in a continuing effort to reverse his conviction, but only to assure the indigent an adequate opportunity to present his claims fairly in the context of the state's appellate process. We think respondent was given opportunity under the existing North Carolina system. Much of the decision in the preceding section is equally relevant to no question of whether their state must provide counsel for a defendant seeking review of his conviction in the court. North Carolina will have provided counsel for a convicted defendant's only appeal as of a right, and the brief prepared that by that counsel together with one and perhaps two North Carolina appellate jurisdictions may be available to this court in order that it may decide whether or not to grant certiorari. The court's review, much like that of the Supreme Court of North Carolina, is likely to There is also a significant difference between the source of the right to seek discretionary review in the Supreme Court of North Carolina and the source of right to seek discretionary review in the court of the former is conferred by the statutes of the state of North Carolina, but neither is granted by statutes enacted by Congress. Thus, the North Carolina but the latter is granted by statutes enacted by Congress. Thus, the argument relied upon in Griffin and Douglas cases that the state, having once created a right of appeal, must give all persons an equal opportunity to enjoy the right. It, by its terms, inapplicable, the right to seek a certiorari in the best in this court may not be granted by the state and exits by virtue of federal statute with or without the consent of the state whose judgment is sought to be reviewed. The suggestion that a state is responsible for providing counsel to one petitioner during this simply because it initiates the prosecution, which led to judgment sought to be favored by Constitution as opposed or is unsupported by either or authority. It would be quite logical under the rationale of Douglas and Griffin, and indeed perhaps more so, to require that the federal government or this court furnish and compensate counsel for petitioners who seek cert here to review state judgments of conviction. Yet this court has followed a consistent policy of denying applications for appointment of criminal offense by persons taking flight and 14th Amendment to impose such a requirement on the United States, we decline to do so. We do not mean by this opinion in any way to discourage those states which have, as a manner of legislative choice, the domestic made counsel available to convicted defendants at all stages of judicial review. Some states which might well choose to do so as a matter of legislative policy may conceivably find that other claims for public funds, with or without a criminal justice system, preclude the implementation of such a policy at the time. The 14th Amendment leaves these choices open to the state.